Um,
Can you hear us, Kirby?
Can you hear me now?
Yes, we can. Thank you. Yeah.
Okay, thank you.
Good morning and welcome to Addington Highlands Committee of Adjustment meeting, Tuesday, July the 28th, 2026. I'll call the meeting to order. Today's meeting is being streamed live via the Township of Addington Highlands YouTube channel. To those present in the gallery today, by attending a public meeting of the Committee of Adjustment, you are consenting to your image, voice, and comments being recorded. Anyone invited to speak will be recorded, and the voice, image, and comments will form part of the live stream. The chair and/or secretary have the discretion and authority at any time to direct the termination or interruption of the live streaming. Such direction will only be given in exceptional circumstances where deemed relevant. Circumstances may include instances where the content of debate is considered misleading, defamatory, or potentially inappropriate to be published. Notice is hereby provided that under the authority of the Municipal Act 2001 and in accordance with Ontario's Municipal Freedom of Information and Protection of Privacy Act, that all information provided for or at a public meeting/consultation or other public process are considered part of the public record. Members of the committee, staff, delegations, and attendees should be mindful of using names of individuals or entities when discussing matters in public. Attendees are advised that they may be subject to legal action if their actions result in inappropriate and/or unacceptable behavior and/or comments. As per the Township's procedure bylaw as amended, all votes during electronic meetings will be recorded votes. All members of the Committee of Adjustment are participating in person from the council chambers, with the exception of Committee Member Thompson, who is participating electronically. Applicants and any other members of the public may participate in person or electronically during this meeting. So just before we start, welcome to the members in the gallery today. It's great that you're here, and you can, when it's your turn, you can speak to the issues. And we have our planner on board as well, Mark Toe, and we will start. So first item here is approval of the agenda. Moved by, I'm going to change our terminology, committee member Yench, seconded by committee member Lavelle. And we'll call a vote. Committee member Thompson.
Yes.
Committee member Hook.
Yes.
Committee member Levier.
Yes.
Committee member Yanch.
Yes.
That motion is carried. Adoption of the minutes of the Committee of Adjustment meeting dated December the 19th, 2026. Moved by committee member Hook. Second by committee member Levier. Call the vote. Committee member Thompson.
Yes.
Committee member Hook. Committee member Levier.
Yes.
Committee member Yench.
Yes.
And that motion's carried. Item 3.2, adoption of the Committee of Adjustment meeting minutes dated June the 18th, 2026. Moved by committee member Yench. Second by committee member Thompson. Call the vote. Committee member Thompson.
Yes.
Committee member Hook.
Yes.
Committee member Levier.
Yes.
Committee member Yench.
Yes.
And that motion's carried. Item 4, business arising from the minutes, because there's none. Disclosure of pecuniary interest and the general nature thereof. None noted. No applications for minor variance. Move on to item 7.7.1, application for consent, severance 2024/10. Wilson. Turn it over to you, Patricia.
Thank you. Good morning. So in 2024, we had an application submitted for consent, and it was approved in December 19th, 2025. It was to create a new lot. It was submitted by the Wilsons. The applicant has been working at meeting the required conditions included on the decision, including the condition to provide a reference plan depicting the new lot, which would be prepared by an Ontario land surveyor. And as the report outlined, the Ministry of Transportation worked with the applicant to determine where the best location for the entrance would be, and it ended up being outside of the proposed lot boundary on the retained land. So the applicant was advised to move that southern boundary to include that location for the entrance along the highway. So it resulted in the southern boundary being extended and an increase in the acreage of 1.14 hectares. So the original application was for 4.3 hectares, increased the lot size to 5.44. The retained land remains approximately 8.09 hectares or 20 acres, which exceeds the required minimum lot area of 1 acre. The revised southern boundary also increased the total frontage. However, it did not decrease the retained frontage below the required amount. And further to this, the ministry did not plan on ever permitting an entrance to the retained land from the highway, as required the entrance be off of the Township Road, being at Bosley Road. So the surveyor laid that out and provided a copy of that draft preliminary plan to the township. And according to the Planning Act, since there was a revision that was quite significant in area, the matter needed to come back to the committee for consideration and to determine whether the revision was considered minor or not. Also included on that survey, it was found that the portion of the old Addington Road was located within the pin of both the new lot and the retained lot. That portion of Old Road is vested, the ministry has vested interest in it. However, it does remain in the pin. It is owned privately and will not have a material effect on the title of the property or result in any further subdividing. So I listed some factors in that report that council committee could consider when determining whether the revision is minor, and that is that the lot area and frontage of the retained land are not being reduced to an amount less than permitted. The Ministry of Transportation has proposed a new realignment in order to permit the entrance. No comments were received from the adjacent property owners during the original proposal and hearing. And Quinte Conservation will require permits for any future development on the new lot and the retained. So in order for the applicant to continue at this point, the survey to be deposited, as mentioned, the committee will need to determine if the revision is minor or not, and staff would then be able to proceed accordingly and either approve the preliminary plan for deposit or recirculate the application with the new lot boundaries.
Thanks, Patricia. So do members of the committee have any questions for Patricia? Committee Member Hook, go ahead.
Is the applicant okay with the revisions? I mean, he would had to been fine with the surveyor.
Yes.
And so he has no questions regarding that, so.
No.
Okay.
Any other questions? No, I don't see any other questions. So there's a recommendation here, then we just have to add the rest to it. And do you want would you recommend a specific wording, Patricia, that would be added to that? If we're supporting this?
If supporting it,
Yes.
that would be, that it be resolved, the report prepared regarding the revision to the site area of consent file SEV 2024-10 Wilson be received, and further that the committee determines the revisions to the application are minor.
Okay, thank you. Moved by Committee Member Hook, seconded by Committee Member Levier. We'll call the vote. Committee Member Thompson?
Yes.
Committee Member Hook?
Yes.
Committee Member Levier?
Yes.
Committee Member Yench? And that motion is carried. Okay, we're moving on to section 8, correspondence. The first one is 8-1, a severance 2025/02, Davison. Patricia, you going to speak to this first? Okay.
So council had received a letter from Mr. Davison regarding conditions on his consent and deferred the matter to the committee for consideration. They also requested that our planner be attend the meeting as well to provide information regarding why the conditions were, why these types of conditions were included in the decision. So we have both the applicant and the planner attending. We can proceed however committee wishes. We can have the planner speak to the reason for the decision and the conditions, and then hear from the applicant, or however you'd like to proceed.
I think we should proceed with the planner speaking and just explaining the conditions first. Is that okay with you, Mark?
Yep, happy to do that.
Okay, thanks.
So, I mean, as laid out in the staff report, I think hopefully clearly enough, and the previous report by Arcadis, typical standard approach for any new lot creation, and I'm saying typical standard, not just Niagara Highlands, but in virtually every municipality, is that any new lot that gets created for permanent year-round residential use is on a road that's maintained year-round as well, so that safe access can be provided to the house that gets built for emergency services, fire, ambulance, etc. The only exception to this is really seasonal, so cottage lots. Obviously, it's understood that in a lot of cases, cottage lots are on existing private roads where you can't provide access and don't provide access currently to or any kind of maintenance. So as in the official plan for the township, as again with a lot of most other municipalities, there is a condition or policy that says that any new lot to be created for year-round residential has to be on a municipal road or county road or provincial highway that is maintained year-round. So that condition gets applied, or that requirement essentially applies to every new lot or consent application for a new residential lot that is put to the township. And so it's fairly rare to, not never, but fairly rare to see applications for new lots on partially maintained or seasonally maintained municipal roads. And when that happens, the condition is that the road has to be brought up to a standard, and the municipality has to agree that they will provide or extend year-round maintenance to the frontage of that new lot. So that's kind of the backstory here. Standard recommended condition for a situation like this, and with the reasoning, as you would expect, that the municipality doesn't want to be approving new lots with new houses on it where they can't provide emergency services to it on a year-round basis. The township has a policy in place about kind of what that means in terms of road standards, so that it's suitable and can accommodate snowplows and anything lesser in terms of weight and turning dimensions and everything else. So I understand from Patricia's report and in talking with her that that's been discussed with the applicant about kind of what the details are of road improvements, so that township staff, public works staff are confident that they can drive their vehicles on the road and provide year-round maintenance to make it suitable. I think the challenge here is that the severed lot is kind of, so you have the main lot and very lengthy frontage along Wilson Hills Road, and the severed lot is kind of furthest or further away from the fully maintained portion of the road. So you've got a stretch of road frontage on the retained lands where technically the applicant doesn't have to improve the road in that stretch. Then you get further down the unmaintained portion or seasonally maintained portion, and then you have the severed lot where the condition is they have to improve that portion of the seasonally maintained road. So there is a bit of a kind of a gap there where I guess the township has to improve it so that it can be accessed and maintained year-round or fully maintained year-round. And I know the township staff, I think, have talked about that a bit as well, met with the applicant on site to walk through what may be required on that particular stretch of road. And I think now I think the applicant continues to have concerns about why it's necessary to do this work, because history from their experience in the area is that it is fairly well maintained. But yes, snow plowing doesn't happen. And I note in the applicant's letter, they did note an incident where an ambulance was required on that road and the ambulance couldn't get through in winter conditions. So I think there is that concern, and the question is, how do we reasonably address that so that there aren't any health and safety concerns effectively by approving a new residence in this location. Well, I'll leave it there, but happy to.
Okay. Thank you, Mark. Maybe what we'll do next is we'll ask the members of the committee if they have any questions on Patricia's report or what you're commented on, Mark, and then after we go through that, then we'll turn it over to the applicant, and then you can present whatever you want, ask what questions you want. So, okay, thanks. So, members of the committee, committee member Hook, go ahead.
Well, I think the question comes down, who's going to pay for the road improvement, right? I think at our last meeting, we discussed, or there was a question, if that road was a maintained township road, that section of it. And I thought that was the way the question was left. So is the township going to pay for the improvement, or are we still going to ask Mr. Davison to pay the $40,000 to make the improvement? So has that been resolved here?
So I probably can't answer that question. So I guess my understanding was, and maybe Brett, because I'm looking at the staff report, said the intent of the road improvements were to be equal to the existing road and not require the road to be improved to a condition greater than the approaching road. Can you add some content to that, Brett, please?
Yeah, that's what we discussed on site with the contractor and with Jamie and Nathan when they were on site. And I believe that the last time when Glenn was there, I believe we had that same discussion. So,
okay, so the existing road, then it wouldn't meet the standard if you had to build a road today. Is that correct?
yeah.
Okay, so then this request is requiring, or the intent here, I guess what we've been asked for in the conditions is that the road would be brought up to the same condition as the existing road that we maintain.
That's what we had originally discussed in the original proposal, I guess.
Okay.
So.
Does that answer your question? No? Doesn't answer who's paying for it.
Exactly.
No, but I believe it was the applicant that was to pay for it. Go ahead, Patricia.
Yeah, it would be, the condition, the way it was worded, was expected that the applicant would pay for it. The requirement is, as the planner spoke to, was that it should not extend any township services. So it wouldn't be the township that would pay for the lot or the road to be improved. There was the strip though, however, was not worded clearly in the decision to include the strip along the retained. But in front of the new lot, it specifically says that it would be the applicant that would improve it.
The additional question on that? Go ahead.
Well, kind of related. I think maybe Mark could correct me if I'm wrong. So he said there's kind of exemptions for cottage roads. Now I live on a private road, cottage road, and there's all kinds of, and we know this, that there's all kinds of cottages that are permanent residents on cottage roads. I wish my road looked as good as this road. And we kind of know that, and I don't think there's any formal agreement, that ambulance fire trucks may not get down these roads in the course of the winter or washouts or whatever. And we live with that. So there's many instances of that case. So cottage roads, people that have cottages are kind of exempted from this when they get a building permit. They get a building permit and saying that it's a cottage, and then it's turned into a year-round permanent residence. So I know this may sound not related, but it is kind of related. It's almost like we have a double standard.
I can speak to that.
Yeah, go ahead, Mark.
You're gonna share. Yeah, it is. And I mean, again, I guess I'll say again, not atypical or not unusual to have these types of policies and have a two-tier system, I guess, of dealing with cottage lot development or private road development versus development on public roads, whether they're maintained year round or not. And I think on its face, maybe it seems you would ask the question, is this fair or is this equal? And I guess the answer is in some ways, no. However, I think it recognizes the reality that we have that most municipalities in Eastern Ontario have cottage lots, have extensive networks of private roads. And so there's a decision to be made. Do you allow any new development on those private roads for fear of liability or requests that the municipality would take over that road and maintain it? Or do you essentially allow for development to continue on those private roads under certain circumstances and have essentially, and this is what Addington Highlands have a condition that says that if you are developing or building a new lot on a private road, an agreement has to be registered on title, recognizing that the access road is not maintained by the municipality and there's limited provisions for access. So, as the councillor pointed out, that's how Addington Highlands operates. That's how a lot of municipalities operate. And so I think and just taking a bit of a broader step back, so the new official plan, as we've talked about before, does away with kind of a clear distinction between seasonal cottage lots, cottage development, waterfront development, and permanent year-round development, because as the councillor pointed out, that has started to shift and has been shifting for some time, where cottages are becoming year-round residents. And so our ability to kind of reasonably assume that there's less use on cottage lots and cottage roads has decreased. And so we have to look at what's the best way to try to regulate that. So I think going forward, there's going to be private roads still, and any new development on private roads is going to be subject to the same kinds of conditions that if you're building a new house or creating a new lot on a private road, you have to enter into that agreement that the municipality doesn't provide services, it's not a public road, etc. And then you've got the other category, which is actual municipal roads. And then within that, we've got the situation like we have today, where some of those roads are not maintained. And I'm going through with staff right now a couple of other applications or inquiries for potential developments on unmaintained municipal roads. And, we don't want to discourage development, whether it's commercial, like resort commercial kind of tourist uses or residential uses. But I guess ultimately the municipality, what we have on the books today is official plan policy says that it has to be, if you're creating a new lot, it has to be on an existing public road that's maintained year round for a permanent residential use. And so for this application, how do we deal with that policy is kind of what it boils down to. And then looking at the roads policy that the township also has about whether it's transfer of unmaintained roads or private roads to municipal ownership and assumption, or upgrading seasonally maintained roads. So we've got these criteria in place. And in this case, the applicant's questioning whether it's fair or reasonable to be able to meet this criteria. And so I think that's why staff have been working with the applicant to try to make sure they're not asking for too much, that the road, at least what improvements have to happen, that it will still be able to accommodate emergency services and a fire truck, to at least check the box of meeting the policies, because that's what we're bound and stuck with dealing today. I think if council wants to modify the policies to say, okay, I just talked about before, we got private roads and we got municipal roads. And then within the municipal roads, we don't really have any kind of equivalent policy where a landowner could enter into a development agreement recognizing that there's portions of the road that may be unmaintained and that they don't hold the municipality responsible for that. So that would be maybe the middle ground in a case like this, where if council wants to approve development on unmaintained or seasonally maintained municipal roads, maybe it means having that development agreement where the landowner acknowledges that they're on an unmaintained or seasonally maintained road and that the municipality won't provide services, et cetera, kind of like a private road agreement. So I think but the challenge is that's not how the condition of the consent is worded. And probably more importantly, the official plan policies and the council's road policy doesn't really allow for that type of approach. So I'm not quite sure how we would apply that kind of middle ground here if council or committee wanted to do that.
Thank you, Mark. I have a question for you, Brett. Maybe you can just maybe provide a little more clarity to it. So the this existing road, the improvements that are required to the existing road to bring it up to the condition to the road that's maintained year round. What does that involve? Because I guess that's probably the biggest ticket item here. Well, I think it is anyway.
Yeah, I think we discussed 4 to 6 inches of gravel on it, A gravel. And then some drainage improvements. The most I guess difficult spot is it goes over a rock knoll there, and to have drainage so the road doesn't wash out. So the other thing I guess that would be it would be have a proper turnaround for a tandem plow truck. So.
And then that turnaround obviously would it be at the far end of where the severed lot is going to be?
Yeah, I think it
Yeah.
would be right around where the driveway area is what we had discussed. So.
Okay. Committee member Hook?
Just to add to that, any idea what a ballpark cost would that be for the township to do that work?
I have not looked into that at this point. I would hesitate to say we do have our own equipment, so so that's a lesser cost, obviously. Yeah, so I can work out a number, but I wouldn't want to say right off the top of my head because I don't want to hold to something that I'm not comfortable with right at the moment.
Committee member Yance? I got you.
Did have it pressed there. I'm just wondering, for my own history, I've lived in this community over 50 years, and it just seems incredible to me that some roads were maintained, some roads became seasonally maintained, and then some become not maintained, and I'm not quite sure how that happens. And I have traveled Wilson Hills Road many times, maybe looking for partridge or whatever when it's hunting season, and driving that road. And I just find that it's very frustrating to me when I know personally that it was maintained, seasonally maintained, and now this is it. So I'm not quite sure where all this happens or how it changes, but I think we need to be able to help Mr. Davison out here and the future owner of the property of that severed lot.
Thank you, Committee member Yance. Committee member Thompson, go ahead.
Yeah, so I'm thinking that we don't want to start building roads forever, like, every case is something like this, but I would like to hear Mr. Davidson on what his proposal is or what he's thinking. And if he would be open to this unmaintained portion of road.
Good. Thank you. So do we have any other members of the committee have questions before we turn it over to the applicant? Not right now, not now. Okay. So who wants to speak on behalf of the applicant? Okay. And Donna, is it Donna? Okay, go ahead, Donna. So just sit, you can have a seat and then, yeah. Just press the red button when you want, or the silver button. As long as the red lights are on, you're all set.
I didn't quite catch what was said, the last comment that was said. If somebody could clarify that for me?
Yeah. So what committee member Thompson asked or suggested is that he wanted to hear from the applicant as to what if they had, I mean, have the words all right, what your proposal was, sort of where you stood on this.
Okay, and if we would be satisfied with it being an unmaintained road
Yes.
going forward. Well, I checked on the Addington Highlands road maintained and unmaintained policy. And it said that for a road to be seasonally maintained after it had been fully maintained, like the Wilson Hills, that there was a protocol that had to be done. So signage had to be put up. And the people who live on that road, which right now are there were only 3 residents on that 3-kilometer stretch of road, needed to be notified in writing. And neither one of those has happened. And that was evident when the ambulance came from the wrong end of the Wilson Hills in the wintertime, didn't know that it wasn't maintained, and drove in and got stuck. So that's a concern that we have, was that it was maintained, then somehow it was deemed seasonal, and now we're into, the dilemma that we're in. The photographs that were handed out shows the work that was done on the Wilson Hills Road after amalgamation by Glenn Mannion. He brought it up to standard, and it has still has this very solid base that you see in the picture. So it needs to be widened a little bit because it's grown in over the years, because it hasn't been maintained to the same level as the maintained part of Wilson Hills. The year that the township stopped plowing the road, Glenn pulled out numerous people at the bottom of the big hill because they drove on it, didn't realize that it wasn't maintained anymore. It was just kind of, so I'm not sure how that decision was made. We're just not going to look after it anymore in the wintertime. We also understood that we were to upgrade the portion, as noted in the notice of decision, in front of the proposed new lot. And now it appears that, which is about 500 feet, and now it appears that it's the whole section, which includes another 900 feet that's in front of Glenn's retained portion of the land in front of the road. Now, part of the road is on our property, so where the proposed lot comes out onto the Wilson Hills, first it comes across a private section, or however you would call it. It doesn't belong to the township yet. It belongs to the farm. It's not a busy cottage road like we're talking about. It has 3 residents. This would make it 4. It goes 3 kilometers between Boundary Road and Freeburn Road, and gets very little traffic. I mean, basically, that's what it comes down to. The road was maintained well until about 5 years ago, when Glenn's health deteriorated and he had to quit farming, and he couldn't haul hay from his farm that had access on Freeburn Road. And he used to he would bring the hay home along Wilson Hills, and the road was always maintained every summer until that point. And then he didn't contact the township anymore because he didn't have the need to travel along there anymore. In the spring and fall, the fully maintained portion of the road gets ruts that are about 8 inches deep. And if you don't have 4-wheel drive on the maintained part of the road, it's very difficult to get in and out. The seasonally maintained road never ruts up. It's a much better path to travel, except that it's not plowed now. There are simple solutions to the snow plowing issue that would involve not having a large tandem plow truck come in. The township pickup truck that does snow plowing comes along the Clark line to do by the bridge. And we're talking about 3 kilometers further distance to do this little section, 1,400 feet of road. And then it would, and the turnaround would be in the proposed driveway. We understand that there are policies at every level of government that need to be considered, but many of them don't recognize the specifics of an area like ours, and that's why we have you. So you know and respect the essence of our township, and we all want to preserve that. So kind of in conclusion, a lot of stress, time, and money has gone into this process so far. And now we have a $6,500 severance that can only be useful to someone from Toronto that has the finances to upgrade a road before they even apply for a building permit. We never even considered selling part of our farm for financial gain. We did it for a young man that's close to our hearts, loves the land the way we do, and has a dream to live in the area where he was born and raised and where his family all still resides. So we hope that you can help us make that happen. Oh, and I did have one question. If I wanted Patricia, if she could just clarify, if we have a neighbor who is looking at building a permanent home, and obviously owns the land on the Wilson Hills Road. And Patricia, if you could clarify what would be required of him if he was to build, because it would be pretty much where across the road or just up the road from the lot that we have proposed.
Did you want to speak to that, Patricia? Or do you want to do that outside of the meeting? Are you okay with that?
Either way, I can speak to it though, and I would also say that Mark could speak to that policy as well.
Oh, okay,
And
go ahead.
he may be even better versed at it than I am, but
Go ahead.
there is the provision for existing lots of record. And that's common in all zoning bylaw amendments to or zoning bylaws, to my understanding, that municipalities allow existing lots of record certain provisions and exemptions to the requirements. And so in this case, if an owner of an existing lot of record wanted to build, and they would be able to obtain a building permit for that lot, there would be a provision that emergency services may not be able to reach them as the road is not maintained. And Mark, did you want to add to that, or did I do that? Well,
Yeah,
enough.
you got it. I'll just add that. So the zoning bylaw, so you got the official plan, and it says no new lots unless they have frontage on a public road. But there are allowances for existing lots that were created, often cases years and years ago, saying they're recognizing that lots from decades ago may not meet the standards of today. So we don't want to necessarily handcuff people in those situations. The zoning bylaw does require that even on existing lots, any new buildings or structures have to front on an improved street. However, I understand the township and council have, as Patricia said, have a a nuanced approach to this where agreements can be entered into to allow for development of a house on an existing lot of record, provided that there is acknowledgement that the road may not be fully maintained year round. So there is I guess that kind of exception recognizing existing lots of record so that they don't remain vacant for in perpetuity if there's a standard they can't meet.
Okay, thank you. Just a question, Donna, but, and maybe you're not ready to answer that question here. So because committee member Thompson brought it up, the question as to whether you were, an option for you was for that road to be, I guess the section is, it's currently seasonal road, is that correct? Whether you are willing for that road to remain a seasonal road and not maintained year round? That just a question he had. Do you have an answer to that, or?
I believe the answer is yes, that we would be okay with that. We would, yes, we would arrange to have it plowed ourselves and look after it ourselves.
Okay, thank you. And I had another question, because I don't know the history of that road, because you were mentioning that it was plowed at one time. So and it was a half a dozen years ago, it was no longer, so it was plowed year round by, do you remember by what? What was actually plowed with?
The township used to plow that road all the time. I think it's been probably 20 years since it's been plowed by the township.
Okay,
Yes, but the maintenance, the last 5 years, I was talking about summer maintenance.
Oh, okay.
Bringing that road up to a safe standard to haul a trailer, a farm trailer with 14 big bales of hay on it along that road, and it was safe. Up until
okay.
5.
So the plowing of it was actually a couple decades ago. Okay,
Yes.
thank you. Patricia, go ahead.
The committee wouldn't mind, I just want to advise as well that, so that the applicant understands that if that was a consideration, that the road be left as seasonal but plowed by a private individual, it would require an agreement similar that we use on an unmaintained road allowance, where the person applying to provide that maintenance to the road enters into an agreement. The road needs to be surveyed, which it is anyway, in this case. Insurance has to be obtained and maintained yearly to be able to provide that work on the road. And that's just what we've included so far, but the township has been working with the solicitor to determine if there's anything else, considering it is considered a township road. So, but at the minimum, insurance would be required for every year to be able to provide that maintenance to the road, a survey of the road, and enter into that agreement.
Yeah, I had a question and I think I lost it here. So the question I have is for you, Brett. Is that existing road that's seasonally maintained? So then it would not require any work to that existing road. If it was stayed in a seasonally maintained, it would be in a condition that, I'm talking about the section that's,
The seasonally maintained
yeah,
section.
yes.
We did replace a culvert in it already this year. Typically we grade it once, maybe twice a year type of thing. And we have in the past put a little bit of gravel on it, especially when there's we had to use it for a detour route when a culvert was deemed unsafe up on Freeburn Road. So, yeah.
Okay, and then similar to, I guess, other seasonally maintained roads, yeah, if a culvert collapsed or something, we replace that.
Yeah.
And as far as keeping kind of the right of way clear or any ditching, that's really just done when it becomes, I guess, in really bad condition and that.
Yeah, when it's required.
It's not done to the same standard as everywhere else. I've been on lots of seasonally maintained roads and, you know, they often end up growing up with brush and then eventually every so many years you might go in and clean it out.
Yeah, we have went through with the tractor and a brusher on it periodically and opened it up a little bit. We haven't went through with our excavator and our big brusher and well, since we've got it, so.
Right.
Yeah.
Committee member Yench?
What are we saying here? Are we saying that the township is going to bring that road up to a seasonally maintained road? Is that what we're suggesting?
No, it's already there. So
Okay.
there would be
so-
no work done on the existing road. Does that go right past the severed property? Is it the same? Is the severed property or to be severed in the
Yeah,
same
the
condition?
seasonally maintained road runs from our snowplow turnaround, just past the Davison's driveway.
Yeah.
Up through to Freeburn Road.
Oh,
So,
okay. It's all the way through there.
yeah.
Yeah, okay. Okay, so, yeah, Councilor.
Yeah,
Yep, go
it
ahead.
sounds to me like most of the items have been met. Is it just a monetary side, the 40,000 that we're concerned about here? Okay, so what if, Brett, you could come up with an estimate if it would be cheaper for us to do it? I think that might be something to consider, and then we can proceed with this. So there'd still be some costs. However, it may be reduced less than the 40,000.
Patricia?
Something else I think the committee and the applicant need to be aware of, and perhaps Mark could speak to this, is that the policies of the OP and the zoning bylaw both require the road to be maintained year round for the creation of the new lot. So then what further planning act applications may be required? Will we require an official plan amendment and a zoning bylaw amendment to recognize this? If the condition is removed that the road be brought up to the required standard. And perhaps Mark could speak to that thing.
Yeah, and I guess just to clarify, like ultimately what we have is a condition of the consent, and that condition comes directly out of the official plan and effectively the zoning bylaw. And it's, so, you know, the committee was correct in putting the condition in, like that was the only thing really to do, because that's what the official plan says has to be done. So now what we're really grappling with is, you know, what can we do to make this road or this portion of the road so that it's maintained year round? I mean, looking at the road itself, like, you know, I have lots of experience in rural areas. You got Cottage up north as well, and so like looking at the road, it looks, as some have pointed out, certainly looks better than a lot of roads. So, you know, from an OP planning policy, you know, checking that box standpoint, what we really need to be able to do, or the township needs to be able to do, is say that, like, we maintain it year round. What that means, I guess, and the degree of maintenance is kind of the question, and is the road able to be maintained with, you know, a different type of snowplow, those kinds of things. But ultimately, that's kind of what the committee needs to be able to grapple with is, can we say that this road is maintained year round? Alternatives where the applicant maintains it or plows it, that probably will work. I think that can work if that ends up being the case. And just trying to avoid having to come up directly against a situation where it's not maintained year round is really the problem here. So to avoid, as Patricia said, an official plan amendment, zoning bylaw amendment. So you're on the right track, I guess, trying to see, okay, is there a less expensive way to get this road up to a condition that Public Works can say, yeah, we can run a snowplow down there, or it can be maintained year round. That's really, I think, the solution to solve the problem that we have, which is trying to satisfy this condition so that the consent can be approved and they can have their lot.
Yes. Go ahead, Committee Member Hook.
So further what Patricia said, if we do an agreement to have that an unmaintained road, and then they will not expect services, then the applicant would still have to pay for the zoning and planning amendment. So we're talking thousands of dollars there. So to me, that if that's the case, I don't think that's an option. I mean, they're going to be spending so much money in paperwork and getting nothing for it. I just see this as just another barrier for development. I think we're just moving backwards. So I would like to proceed with Councillor Levelier's suggestion that we defer this until Brett comes back with a price of what the township could do to bring it up to a minimum standard, to have that a year-round maintained road. And it might not be that much money, because I think that would solve all the problems.
Yeah. Did you want to say something, Patricia? Go ahead.
I don't really know how to address it, other than I think the municipality would want to be careful as to assisting with the development of new lots in that manner. It's just something that you wouldn't want to set precedents where you're creating roads for these lots to be developed, and when our policy requires otherwise. And I don't know if Mark has anything to add in that regard, but I just think we would want to be cautious of doing that for development.
Yes.
Yeah. So
Did you have any comment, Mark?
yeah, just briefly through you, Mr. Chair. Yes, I mean, I agree with Patricia, and there is a council's policy on the roads, how to deal with situations of unimproved roads. One of the policies and one of the points and the purposes of it is to essentially make sure that the general tax base doesn't pay for new development. So I think in this case, it's, there seems to be a history where the municipality did maintain this road year round, and then it stopped at some point. And so is there a middle ground where some maintenance can be provided and it's not that big of a requirement to get it up to standard where it can be maintained year round? One of the thoughts I had was, and this happens in other cases where an applicant has to improve part of their frontage, or a portion of their frontage to enable development. So say putting in sidewalks, for example, or improving the road, and they can contribute essentially cash in lieu of that improvement, and the municipality has that improvement on their books to do the rest of the road or the frontage, extend the sidewalk, whatever it is themselves. To Patricia's point, you want to be careful, or municipalities want to be careful that it's not being done to facilitate a single development, but I guess where you have that history with use of this road, maybe there is something to that, where the municipality may wish to reinstate some of that road, because it sounds like there was some history there of how it was used and maintained.
Okay, so look, yes, go ahead, Donna.
Thank you. Officially and legally, the road is still a maintained road because it has never been the protocol has never been met to deem it a seasonal road. So if that's the case, and we found that discrepancy at the council meeting when this was discussed, that it is on 2 lists. But that section of road that we're talking about has never been officially deemed a seasonal road, or has become a seasonal road. So technically it is still a maintained road. all the way from Boundary to Freeburn.
Well, I can only speak to it partially because we had, there was a lot of vagueness with I could say uncertainty, because we didn't have a documented, a policy on road maintenance. And so we took all of the roads and looked at every single one of them and did the very best to our ability to categorize to what point on that road, what distance, what segments of all these roads that may have been questionable, following sort of our past practices, you know, generally as to what we had been doing, and then came up and then defined, you know, specific distances in on all these roads and segments which were year-round maintained, seasonally maintained, or not maintained at all. Maybe there's a, I don't know the specific one, if there's some error or confusion in what was done with it. I have no idea. I don't know. Can you speak to that, Brett, or?
I can speak a little bit to that. That was my error, the definition between where the seasonally maintained portion was and where the fully maintained portion was. I believe the distances are correct, but it just shows that there's 1 kilometer roughly that's maintained, fully maintained, and then there's 0.8 of a kilometer that was seasonally maintained. That doesn't mean that previous to me coming here, that wasn't fully maintained, that road. I'm just going by the history that it was before I came here that they stopped plowing that portion up over the hill, so.
Okay, thanks, Brett. Yeah.
Glenn would like to speak if that's okay.
Yes, you may.
He's up.
I'm fine. Thank you. I have difficulty speaking. That's why Donna is. But after the ambulance got stuck, and I'm sitting in the kitchen, and the fire department's trying to pull them out, and I'm waiting for another ambulance from Madoc, suspecting a heart attack. And then after that, when I got a phone call at 10 o'clock at night, that there were 2 ladies stuck down at the bottom of the hill, and they were freaking right out because at that point in time, there was nothing that indicated it. I went down and I got them out. I got them up to their place, which was Adrian and Norm's, which is the farm on the end of the Freeburn Road. And they were shook up bad. I went back. I could not pull their car. If I had, I would have been liable for any damage, the same as you would. Then I plowed the road for them. And the husband came and got them out. So I thought, I've got to find out why. Number one, there's no signage, there's nothing. So I did. And what I found from the Municipal Roads Act is that, number one, when you go from a category maintained road to a number 6, they don't really call it seasonal anymore, it's number 6. Then you have to do the following, this protocol for all townships, no matter where they are. And that is, number one, when you've decided to do that, you have to notify all the people that have land there, because once you move it down, you've reduced the value of that land. Number two, once that's done, it's usually in the newspaper or on your media. And then number three, as a council, you pass a bylaw changing it from maintained to level 6. Now, once that's done, then legally, your responsibility to prevent liability and lawsuits is that there must be a sign put up at the beginning and the end, and that sign must contain the fact that it is a seasonal road, if you like, that it is plowed from this date to this date, and that you use it at your own risk. And at the bottom of the sign, you have to put down your bylaw. I've lived there for 40 years, it's never been done. It's a maintained road. So now, basically, maintain it up to that lot and then put your signs in. And when you're doing that, think about the Deer Rock Lake Road. There's no sign. Think about the road that goes from O'Donnell Road out to the graveyard. There's no sign. And yet there are 6 lots on that road, the O'Donnell Road up there, that are subdivided. Each one has a well. So what are you going to do? Are you going to have a reasonable approach to things? Or are you going to do exactly that and say, no? First of all, you better get a sign up. Thank you. And do it right.
Yes. Thanks, Glenn. So we have 3 scenarios. So one is it stays the way it is, you know, the Committee of Adjustment decision, and then the applicant has to bring it up to say to the standard of the existing road. The second scenario is where the township has, and to what degree, does some work on that road to bring it up to a standard that the township would expect. And the third one is that it is that it stays as a seasonal road and plowed by privately, and there's a development agreement, there's a whole bunch of other things. So I realize if we defer this, obviously it stretches it out, but maybe because this thing has so many issues around it or factors, maybe those 3 scenarios should be flushed out. The first one, as is, it's already been documented. The second scenario is where the township does some work and upgrade it, where we would have to put together, know what that would cost us to actually do that. So there'd be some work for us to do that. And then it would be year-round maintained. And then the third one is so that you understood that also clearly what would be involved if it was left as a seasonal road, and all the hoops and steps and costs that would be associated with it staying that, and that you would have to enter into a development agreement, there would be insurance, surveys, et cetera, et cetera. So if there was a motion or resolution by this committee that we have these 3 scenarios, the first one we don't have to do any work to flush it out. The second one we do have to get some cost on bringing the road up. And the third one is a clear understanding for you as an applicant, what you would be faced with in costs and processes if it was to stay as a seasonal road, and we made that exception. I'm just throwing that out as, am I missing something? Yes. Committee Member Thompson?
Yes, so, after the applicant's made his statements here, it seems to me there's a bit of a gray area, and I don't think we probably have any documentation stating when we did maintain this road or when we quit maintaining it.
Yeah.
And I think it would be wise for us to try to investigate that and see if it was a maintained road at one point and for what reason we stopped or whatever. And perhaps we should go back to being a maintained road. I'm just saying if it was before, but I just don't know that we have the documentation to prove that it was. Although I know that the applicant has stated that it was. So I'm just curious on that.
Oh, yeah. Oh, yeah. Go ahead, Brad.
I'm sure Helen's gonna confirm with me, but or agree with me on this, but I do remember going down through there with a school bus when I was young. So that's quite a few years ago that it was maintained so a school bus could go through in the summertime. I don't remember going down it in the winter time very often though. So
maybe that can be in our second scenario of us keeping it up to the standard that we just look into a little bit of history, or maybe that is the history we're aware of. That's maybe all the history we could find. Yeah. Yes, Patricia, go ahead.
I think the history would be something we could check into. I'm assuming that at a time of amalgamation, if it was approximately 20 years ago, they stopped plowing, that at time of amalgamation, all the roads were looked at and determined which ones were going to be maintained fully and which ones were going to be seasonal. And likely that was the case at that point and we did, if I recall correctly, we did have all these distances in a much earlier bylaw as well. So I'm assuming that it came from some original decision of council when Addington Highlands was amalgamated.
Thank you.
Thanks, Patricia. That's, I forgot about amalgamation. But at the end of the day, if these roads were once maintained, I don't know how many roads, O'Donnell Road was another road. We essentially, whoever the township was at the day, essentially cut off any development. And I just find that really hard to believe, that why would anybody do that? People own property and they can't get to them part of the time, and was maintained, then it's not. So anyway, it's just been a bugaboo for me for many years, and I know council members know that because I talk about the O'Donnell Road lots of times, and it should be a maintained road throughout. Thank you.
Yes, go ahead, Councilmember Hawk.
Are you ready to entertain a motion?
Yes, I am. Very
Okay,
interesting.
I'd like to make
Yes,
one.
the applicant, did you want to say something else? Go ahead, Donna.
Yeah, just one more thing. We're talking about a young man who's trying to stay living in our area and to have additional costs put on top of what he's already spent and what we've already spent isn't realistic. It's not something that he's going to be able to manage and then look at building a home after that. So we really ask that you weigh this with your hearts.
Comment noted. So this, yes, so the second scenario would be where the township would bring it up to whatever standard the township wanted. But we would need, I think for the committee to make a decision, they would need to know that cost. So I'll turn it back over to you.
Okay, so I make a motion that we proceed your option 2, that the township upgrade the road, but we don't know what the cost is, so I'm recommending in the motion that that Brett get back to us with an estimated cost, so we have to know for the next council meeting, so the decision on this will be deferred until the next council meeting. I think that's enough time to get a ballpark price, Brett?
And next council meeting is next week, right?
How about a month from now? The second one.
That's easier because I won't be at the next council
Right.
meeting. I apologize for that.
Okay,
But
then a month from now?
Yeah.
Second council meeting? And just further to the motion, I don't see a problem with us dealing, and I understand the policy aspect of it, but I think there are extenuating circumstances in this, and we can take it case by case. We've done it before. So I don't have a problem with that. So that's my motion.
Patricia, do you have a question or comment?
Just to clarify on the options with the costing, that was to bring the costing back. And you also wanted in the other option where the applicant would know if it was left seasonally, what would be involved in that? With regard to the costing aspect of it, is it to bring the cost back, understanding that the applicant would then pay those costs if they are lesser than what their contractor was requiring, and so that they didn't further require any other Planning Act applications? Like it would be, here's the cost that it would take for the municipality to do this work, and the applicant pay that fee? I'm just not certain what was.
Deputy Falk,
My motion is that the township pays the cost.
okay, so I guess that'll be up to the committee to recommend. So that's what he's making in the motion, that we explore this option of the township covering the cost of bringing the road up to to the standard the township requires. I have to put it that way because it isn't the standard that's in a new road standard.
Mr. Reed?
Yes,
Yes,
go ahead.
I'm fully in favor of pretty well everything we're saying here, but I would still like to see if this was a maintained road. If we have that documentation, then that gives us an opening that we aren't just doing another unmaintained road for an advantage of doing another lot, because that, like it was stated earlier, that opens up a real can of worms. Like there could be a lot of people who say, well, now you got to do my road. But if this was a maintained road, then I think it gives us the opportunity to say, yes, we can do this quite easily.
Yes, no, I agree with you. And we're just trying to flesh out this motion because it was suggesting earlier that the history of this road, that it be part of this motion as well. Yeah, go ahead. Committee Member Hook.
If Councillor Thompson would like to make a friendly amendment to the motion to check in, making that part of the motion, that if it was maintained at one time, I would be fine with that. And then
Yes,
if it was, and if it was maintained in the history, that we still proceed with the township upgrading the road.
Yes, I'm in favor of that.
Yeah. So Patricia's busy writing here. So.
Yes.
We'll give her a minute so we can get them. Did you have a comment, Committee Member Yatch?
So what happens if it comes back and there's really no documentation? It's just that we know how townships ran a few years ago. It wasn't quite as tight or as maybe as organized as it is now. So what would happen if the history comes back and says that it wasn't?
Well,
You have to make
yes.
revisit this again, I guess.
Maybe can't answer all those questions, but I suspect the history will come back with will be just verbal history. It probably won't be documented. It'll just be what people remember. I cannot imagine you're going to find it documented somewhere.
I'm good with that. I'm good with that also.
Yeah. Go ahead, Brad.
We may be able to reach out to some previous employees too. They might have some history. So that because we have some local previous employees that work for the township.
Yeah, we have some retired people, so people that. Okay. So let's get this one first, and then we'll see whether so this one is really for the township to come up with a price to bring that road up to the standard the township requests and to obtain the history of this road section as I want to say its maintained or unmaintained history of it. So, and I believe Committee Member Hook was saying with the intent that the township would be covering the cost of that, any upgrade. So we have both the cost of the upgrade and the history of the road as to being maintained or unmaintained. That's part of that. You're okay with that? And the mover and the seconder, we'll get Patricia to read it in a minute. The only question I have for the committee is, do we want our staff to also, at least for the applicant's information and for ours, to identify if it was left as a seasonal road, what all would be comprised of getting to that point where it could be a seasonal road, or do we not want to spend the time on that? That's a staff time it would take. It's not to do the work. It's more to say, these are the steps and these are the approximate costs it would take to go through that. Or do you not want to go down that path at all? Just so you know. Yes, Councillor Thompson?
Yeah, so we kind
oh.
of we talked about that earlier, you know, and we're just talking about it's going to be added costs if we have to do amendments to the official plan and to the zoning bylaws. So I'm thinking that we're probably not, or I'm not probably in favor of that, but I don't know how the committee feels.
Thank you. Unless there's some desire for the committee to go down that path, we'll just stick with this motion. Okay, it's looking like that. You have something you can read, Patricia?
It may not flow perfectly, but it would be that staff do investigation to provide an estimate of the cost to bring the road up to the standard required and bring that estimate back to council for consideration. And further, that staff gather the history of this section of the road, whether it was maintained in the past or not. And further, that it be recommended, it be taken to council that council pay the cost of bringing the road up to this standard. And
Yeah.
I'm not certain if you wanted something added that if it was maintained in the past, that council continue that maintenance.
I don't think we need that. We just want to know. I think we could factor that into it. Just once we know the history and once we know the cost. Yeah. Brett, go ahead.
And just for my sake, you're just talking about to where the turnaround would be type of thing. You're not talking about the whole remainder of the
Yeah.
road for.
Yes, I believe the mover and seconder. Yes, exactly. That's what we're talking about. To the end of to where the turnaround would be. Yeah, you include that in there too, Patricia, that. Okay. Okay, any other questions from Committee of Adjustment?
Is there a definite timeline there? Did you include the council meeting a month from now? We should have a timeline on it.
Okay. Mark, did you have your hand up?
I
No.
did, sorry, I'm not sure if we fully fleshed this out, and just as the committee is talking about options and what might be investigated, I'm just looking through the official plan and the zoning bylaw and thinking about how we can address this comment or address this condition. The way things are worded, it does appear that similar to how council treats or the township treats a house on an existing lot, the way the wording is done for what a maintained or fully maintained public road is, it does seem to allow for private maintenance agreement to be used, so that it could be privately maintained as long as the township satisfied through an agreement and insurance, et cetera, that maintenance is adequate and, and secured. So I think if you're looking at alternatives, that does seem to be one that would check the OP and zoning boxes in this case and allow for that condition to be satisfied. I think we have to amend, or the committee would have to amend the condition. But I think that is another option on the table if what committee is considering right now doesn't pan out or doesn't work for some reason. I think just to keep in mind that is, I think, an alternative that could also be considered.
Thank you, Mark. And yeah, just a sec. And I believe that the committee doesn't want us to gather any information on that option yet. That's correct? Okay. Yes, did you have a comment? Yeah. Go ahead. You have to speak to the microphone, please.
As to Mark's comment there right now, is that when he says privately maintained, now you're talking about like a private contractor as far as like Knoll Construction, who is already insured, is that correct? To plow the road, maintain the road? Or are you talking about the the landowner or the applicant getting insurance?
So Patricia, you can speak to the insurance aspect of it, yeah.
Thank you. It would be the landowner, so it would be an agreement that would actually get registered on title. So it would be, or at least that would be our goal if land registry permits it, that the landowner would have insurance. If you're hiring a separate contractor, they're going to need insurance as well, and we can
Correct.
include that in the agreement.
Correct.
But what we have been doing in the past, all of our agreements is the landowner obtains the insurance and continues to have that insurance yearly and provides us with a certificate of that insurance.
And what does that insurance cover? Like, this is liability, like as far
The
as,
construction or the maintenance of. So if it wasn't the construction, it was just the maintenance, it would be to insure you to provide maintenance on that road.
even if the landowner agreed that it was gonna be like a contractor that was gonna do that seasonal maintenance?
Yeah, and I think the idea behind it is that, others will still be able, we're not going to we're not closing the road, so that others will still be traveling over it as well. So you have to maintain insurance that provides that access, that covers you should anything happen when someone else is traveling over that road.
Right. Okay, so just one other question, and this goes back to what Mark had said and what Mr. Thompson had commented on as far as an existing landowner. I mean, to me, I don't think it has anything to do with the road, because you're telling me that an existing landowner can sign an agreement to say that he's okay with an ambulance not being able to maybe make it down that same road that you're telling me that an applicant who has a severed property needs to have a maintained road for the ambulance to go down the same piece of roadway past an existing property that's already there. To me, it doesn't have anything to do with the road at all. It's about policies and provincial legislation, which in my mind is why we have a council and why we are sitting here today to maybe come to an agreement. Again, like I said, if it was agreed upon by the landowner or the severed lot that they were going to sign a piece of paper the same as an existing landowner, that they were going to not be liable, or that the township's not going to be liable that an ambulance traveled down that road or couldn't make it to them. As Ken Hook had pointed out, there's lots of places that have that we understand that. It's not like it's an ambulance didn't make it here because there's a snowstorm. We understand that there's snowstorms and there's circumstances where an ambulance can't make it. We're not going to put the blame on anybody. And I mean, I understand that the township looks at that as a liability, but if the severed applicant agrees to that, then I don't see the problem, because it has nothing to do with the road at all. Zero. Thank you.
Thank you. Thank you for your comment. So any other discussion? We have a motion on the floor. Okay. So we have a mover by committee member Hook, seconded by committee member Levier. Any other comments? Call the vote. Committee member Thompson.
Yes.
Committee member Hook.
Yes.
Committee member Levier.
Yes.
Committee member Yench.
Yes.
And that motion is carried. So on behalf of everyone, that is a classic example of democracy. And there's nothing wrong with long discussions sometimes, because you got to flush stuff out. So yes, it's been over an hour, but this discussion is important. So thank you for taking the time, and we will move on to the next item on the agenda. Okay. Yeah. Okay, we'll move on to item 8.2, Frank Smith, severance 2025/07, some decision conditions. It was brought forward from deferral. And you're going to provide an overview. Patricia, go ahead.
Thank you. So yes, this was an application to create a lot addition in Effingham Township from Part Lot 30 and Concession 13. It was approved in October of 2025. The lot addition was being taken from a large parcel which operates a campground and added to a smaller residential lot along the road. Included was a copy of the decision, which included the conditions, and the conditions are to be complied with in order for the Secretary Treasurer to issue a certificate of official, which finalizes the consent. Standard conditions were included in the decision. They were to require a survey, a statement regarding the conditions and certificate of the official, the draft transfer documents, consolidation of lot addition lands with recipient lands and cost to do so, and a condition regarding taxes and debentures be paid in full. Those are all standard conditions included in all of our consent decisions. Included in this one in particular was a decision, in this decision in particular was a condition that the owner of the retained lands obtain an access permit for the western entrance as the commercial entrance and further confirm the location of the western entrance if it be found to be on a municipal road allowance, then enter into an agreement with the municipality with respect to maintenance of that portion of the road allowance to the satisfaction of the township. The applicant had advised staff and the planner that the western entrance was a viable entrance, and given the fact that the eastern entrance is not located on the applicant's land, the condition was brought to the committee in order to bring the law into conformity with the official plan. The costs incurred by the municipality with respect to the Planning Act applications are recovered from the applicant. This practice ensures the cost of development is borne by the developer and not all residents of the municipality. And that included costs related to the planning consultant and legal fees incurred. Costs for surveying, applicable studies, legal fees, and the transfer of land are costs borne by the applicant. That was just to provide a bit of the outline as to what the costs are involved with an application. The applicant is here and would like to speak to the committee about the conditions, and I think perhaps even have the conditions explained. Thank you.
Yes, come on up, Frank.
Okay, so there's probably a lot of this I don't understand. But my situation is I have the trailer park situation, my property. I have two entrances, an east entrance and a west entrance. The east entrance, I have a permit from the township for that the township was there, approved it and everything, and never been a problem. The west entrance was old and existing, but I did improve it. And I don't understand why either entrance has a whole lot to do with the lot addition. That's property off the township road, which the lot addition's already been approved. And then they tell me I gotta do a zoning change. I would have actually thought when an application for the lot addition gets approved, the zoning should be automatic. But however, I've paid for a zoning permit and it's being held up, I guess, because of these entrances. There's, I understand, have no idea what entrances could have to do with zoning. And but there is two entrances there. The one there was no permit for on the west side. Royce Rosenblatt was the road boss, and he come and had a look at it when I put it there and said, you know, like, no problem. There's no old in there, just carry on. And we made a big area there for parking, which he was happy with. And why are we stuck in this rut today? It's been 4 years trying to get a lot addition on a piece of property that's only benefiting the existing thing. I just don't understand it.
Okay, so Yeah, and I think I'd have to actually read this again. The west entrance, it was the issue of just verifying, was it Patricia, that the west entrance was actually on private property? And if it was on the road allowance, then it required an agreement to use it?
Yes, that's
that-
right. And obtain an entrance permit, a commercial entrance permit for it. So verify that the lot is on the private land. And if it's not, then the survey, we need a survey of it and or at least a description of it that we could use in an agreement and enter into an agreement with the municipality to have that entrance over the road allowance.
Thank you. Then the east entrance, Frank, that east entrance, does that run over another private property
Uh,
or not? Yeah.
when I built the driveway there, there was an old fence line there, which was determined to be the property line with the existing owner, myself, the township, everybody. The old fence line still shows on a survey. When my brother owns the property to the east, when he got it surveyed, the line ended up over further into the driveway. No big deal. It's unusual land anyhow, and it's a wedge the size of this room kind of thing. Part of it's on the township road allowance, but there is a little wedge on across his property.
Oh.
But it was existing and it's been there over 20 years. I feel it should be grandfathered in anyhow. He hasn't got any complaints about it to the best of my knowledge. Never was complained to me anyhow. And, but it's like an axe being held over my head here to buy this property and change this address, get it, or actually get it over onto my property, which is a big rock cut and very expensive thing to do. Why do I even need to worry about this east entrance? Why has it got anything to do with lot addition or the zoning? It's 300 yards from these other properties. It's not, it's adjoining. And so Patricia at one point has spoken to my brother, which I don't speak to and haven't for 30 years. To sell me the property and transfer. Well, he sells to me for $1. Yeah, now I'm gonna be in a $10,000 bill here with surveying, and I don't feel that it should be at my expense anyhow. For two reasons. I don't think that the driveway has anything to do with anything. Just leave things the way they are. The other is the township okayed a severance there a few years back for my brother. This was a situation at that point. So they moved the severance over 30 feet from that line, which should have never been allowed to leave a 30-foot strip of land between two properties. You know, I'm gonna say 300 yards long or whatever it is, long strip of land, 30 feet, useless to anyone. Just to accommodate that wedge up there, I guess, is why it was done. And it should have been addressed at that time at his expense, not mine, now 20 years later. So, and both of them are on my property. The driveways are on my property. Yes, it's a little narrow at one point on the east one. The west one is, I'm gonna guess at 30 feet. Have you got anything from the surveyor, Patricia? Like against my better judgment, I paid the survey company to put the corner stake in on the west corner. And which was a condition on I do that. I didn't feel I should have to prove that it's my property if the township doesn't agree with me, then they should prove it. They own the road allowance. They should say, here's my line. Why do I have to pay for saying, here's my line? It's, and you know, my line is, my driveway's 30 to 50 feet over on my property. And I had to pay to have that pointed out, I guess.
So Frank, you're saying that survey stake is on the south, I guess the southwest corner of your property? Is that where you had that
Yes.
put on? Right at the corner where it would meet the road allowance and Terry's Lane?
Yes.
Right at that corner?
No,
That's where you say the stake is?
Terry's Lane,
Pardon?
nothing to do with Terry's Lane. It's on the southwest corner, that's the southeast corner on Terry's Lane.
Oh, okay, I see what you're saying, yeah. But it's on this okay, on the southwest corner where that strip of property runs up along the road allowance, no?
There's a strip of property, my property, along the road, there's a township road allowance
Yeah.
going north and south on the west side of the property.
Mhm.
My driveway is, I'm gonna say 30 feet from the corner stake over to the driveway.
Okay. Running up parallel with the road
Yeah,
allowance.
parallel, yeah.
Okay. Yeah, so I don't, yeah. So, yeah, go ahead,
I'm just looking at the
Councilor
torn
Yang?
diagram here. It shows one entrance, but where is the second entrance? I can't see it on here. Am I missing something or like you're talking west and east and I'm not sure.
Oh, so the second entrance, I don't know, it's in here somewhere.
I don't think I have.
It's on the southeast corner. Pardon? Yeah, go ahead, Patricia.
So yeah, the sketch doesn't include the southeast entrance as it's actually on the neighboring lot.
See what you're saying.
Yeah, okay. Go ahead.
And sorry, further to that, so I'm just looking back at the conditions. So the owner of the retained land obtain an access permit for the western side site entrance as a commercial entrance. So that's the first part of the condition. They get a commercial entrance permit for the west entrance. And further, the owner shall confirm the location of the entrance as being wholly contained in the retained lands. That's the second portion. So the entrance be located within the lands. Should any portion of the approved entrance be found to be located on the municipal road allowance to the west, the owner shall enter into the agreement with the township regarding maintenance of that portion of the road allowance, all to the satisfaction of the township. So we just need that confirmation that the entrance is located 30 to 50 feet from that municipal road allowance.
Okay,
And if
that's
you-
fine, that's been done, but my argument still is. Why did I have to pay a surveyor to prove where it is, where the corner of your property is? And I have a driveway, existing driveway there over 20 years that's been approved by the township. And all of a sudden Frank has to pay a surveyor to come in and prove that he owns what he owns. Why didn't the township prove what they own and say, hey, you're on my property? Or you're not on my property? You know what I mean? Like I'm not really whining here. I've already paid for it and it's done, but I just think it's wrong. And
Sorry, I'm just reading the comments because I didn't quite hear that.
I just think that that's wrong. Why do I have to keep paying all the time? And it's like, you know, I pay taxes on it, and now I gotta prove that I own it. And
Mark has his hand.
then there's
Mark,
no
okay.
reason to.
Yeah. Thanks, Frank. Mark, did you have some comments?
Sure, and I'll maybe just try to
Yeah.
help. Well, I guess fill in some blanks from our perspective. And if I can share my screen, I'm not sure if it's going to let me. Oh, it's not. Send the request and maybe you can share the screen and I can share. But I guess just on the on the question of the location of the western entrance and why there is a condition required to demonstrate that it's within the property, Patricia, on that point, my former colleague Holly, I think had recommended to include that condition. Do you recall why we had that in there in terms of, I think there was some question about whether or not that western entrance was fully contained on the property. And since we already had a situation on the east side where the other entrance wasn't contained on the property, that's where that condition came from, to make sure that we had it like a fully on-property entrance to deal with.
That's correct, Mark. It was to make sure that we had a legalized entrance, as the existing entrance on the east side was not located on the applicant's land.
Okay. So
The argument is why at my expense?
through you,
You know,
Mr.
like,
Chair,
You're the one that want, what's the condition on there? And to prove that it's not on the township property. Why did the township prove that I wasn't on their property? You know, I was.
yeah.
Any-
Through you, Mr. Chair. Yeah,
Yes, go ahead, Mark.
Because the application was, if you hadn't filed an application, there wouldn't have been a request to deal with it. So I think in the cases where there's an application filed, then the onus is on the applicant to demonstrate that they have adequate access. So that ultimately was what it boils down to. So I'm just for the committee, so they can be aware as we're talking about what we're looking at. So this is the east entrance. And I understand, this is obviously the functionally, Mr. Smith's, the entrance to the park, signage, everything else, presumably addressed this way. And so wants to maintain this as the existing kind of main entrance to the park. The western entrance that we're talking about is down here. So then there is an entrance here with a road going up. The condition that was put on the consent was that because that other entrance isn't I'll say quote unquote legal entrance, because there's no easement there. The condition was to get a commercial entrance permit for this entrance, so that at least the lot has one legal access to it. And so the reason why it's being brought into this lot addition application is because when we're doing a lot addition application, when we're doing any changes to lot fabric, one of the things that we have to look at is, is there existing accesses to the property? Probably even more important when it's a commercial property. And so the application is the opportunity to make sure that everything existing is legal, there's proper accesses in place, etc. So I think in this case, the condition is to make sure that there is at least one legal access. And so to get an entrance permit here, I don't know what's required in terms of from Public Works to get an entrance permit to at least legalize this access. That isn't to say that, separate from this lot addition application, Mr. Smith can't, go out and resolve this access. So with the neighbor and get that in place, and then he can continue to use this as the permanent legal access to the camp. It's really just to check the box on the west access and make sure that there's at least one confirmed legal access that's not disputed, and get that in place. And then the consent can be done, lot additions done, and Mr. Smith can try to resolve, getting a full legal access through here at his time and leisure. Hopefully that
Thanks,
helps.
Mark.
Okay, well. The problem I have with that is I don't feel I have to get a commercial access, take out a permit for a commercial access when it's a minimum of 20 years. It's probably pushing 30 years. The driveway has been there. And it's got $30,000 for the signs and signboards at it. You can tell by the pictures. There's been a lot of money spent there. If that isn't already a commercial access, I don't know what you'd call it. I shouldn't have to take out a permit today when the township has changed their laws or whatever. It was fine yesterday, but it's no good today. and now pay Frank. It's like. I just don't agree, sorry.
Go ahead, Patricia.
And just one other thing to add for consideration when we're discussing this is that the entrance on the eastern side, we did receive concerns from the property owner, that the entrance is on his property and the liability of such. And as Frank mentioned, we did work together to see if we could come up with an agreement for a lot addition to the commercial property. No agreement was reached, but if there should be we need to legalize this legalize access to the property, and it's to your benefit as well for any future development. You know, if you wanted to do something and you come to us and we know that there's an issue with the entrance, it could always be something that comes up. So it's for your benefit for the future that there be legal access to the property. Say you went to sell that entire portion, you want to ensure that you know, it's found if a lawyer looks at it, that there's legal access to the property. So it's to your benefit as well that way. It could be that you get a lot addition and obtain part 3 on that other survey and own that entrance to the east. But since that's not the case, the best way to do this was to require the existing entrance to the west be legalized with the issuance of a permit and confirmation that it was located on the land.
Grandfather did. After 30 years, there's all kinds of stuff that's grandfathered in. And just like them last people that was here, that's bull. Them people owned that property before the township changed their ruling, and all of a sudden their property that was worth 100,000 is worth 30,000 because they can't do lots. The township made the wrong ruling there. It should be, they should be able to take severances off their property as long as they're legally documented that they're on an unmaintained road. But that's the same with me right there. Like I have, and I've done everything to the best of my knowledge and the best of the township's knowledge at the time, and now you're saying it's not good enough. Just because I want to add a little bit of land to another lot, and that was all done before there was even zoning in the whole area, and now you've put zoning in, and now you're saying you've got to get a zoning application to do this, and on that east entrance, it's fine to say, okay, I buy the property from my brother for $1, but then I have to survey it. I have to change the zoning on that. I have to do a lot of addition. It's like pay. And I've never done anything wrong here. All of a sudden the township's ones that's in my is picking on me, saying, oh, well, here, clean up this mess and just pay for it. I don't have a mess. I never had a mess. But you've changed the rules, not me.
Yeah.
Back to grandfathering.
Yeah, I hear what you're saying, Frank. Without going into a long diatribe on my own part here, it's one thing that has certainly occurred over in recent years is in the townships involved in a number of them, issues where, and some of them are very costly to the ratepayers, because we're dragged into legal, I'm going to call it civil lawsuits where people are in dispute over whether they have a right to cross a certain piece of property or not. And we're seeing this more and more. And we have, I mean, there's policies and land use policies in place, and they're there to protect you, and they're there to protect the future buyer. Because as Patricia pointed out, if you went to sell this property and then you discovered the legal access wasn't exactly clear, you thought it was clear, it may have been that way for 50 years, And now you're going to be dragged into that, and you would have to deal with it at that time. And honestly, you would probably say, this is the township's fault because they let me go, they just let me do something in the past when they probably shouldn't have. So
That's a
perspective
le-
of Tricia,
called
just,
legal encroachment.
pardon me?
It's called a legal encroachment.
Yeah, so,
That's legal, and if I go to sell my property,
Yeah.
I have a legal encroachment. And I've
So-
bought a lot of properties in my time
yeah.
with legal encroachments on them. And the neighbor's house is 10 feet over the line. He has a legal encroachment. And can't tear his house down.
So if there's some, regardless of how you do it, there's a couple options to go with the east or the west for you. One way or the other, you would need to, I guess, demonstrate that you, for your benefit and the future buyer's benefit, owner's benefit, that you have a proper approved commercial entrance, one way or the other on either end.
But am I not grandfathered into a proper commercial entrance?
I'm no expert, but my understanding is no, there's no grandfathering.
Grandfather, not, it's existing.
Yeah.
It's been
Yes.
existing over 20 years, I think.
Mark, can you speak to that? Oh, you're muted, Mark.
Yeah, sorry. So through you, Mr. Chair, so on the point of whether there's any grandfathering of existing private roads or entrances, there is legal case law and precedent about if you have a private road that has existed for typically it's 20 to 25 years or greater, there can be legal grounds so that road is, essentially the private owner benefiting from it can maintain that road. So I guess Mr. Smith certainly does have the option to get a legal opinion that would confirm that he does have legal access over that, essentially like a forced easement, if you will, similar to like a forced road. So if he wants to show that to the municipality, then the committee could consider essentially that condition about the west entrance effectively being satisfied by providing that he has evidence that existing east entrance is in fact legal. So that might be an alternative. I think the other thing just to point out is that in terms of an entrance on the west side, the commercial entrance permit fee is, I think, $75 from what I understand. So in order to meet this condition, it could be as simple as a $75 permit fee for the west entrance. And then at least the lot addition can be finalized and the consent can be done. And Mr. Smith can continue on if he wants to maintain that east entrance. Then that's can be separate from the lot addition and at least the lot addition is complete. So.
Okay, I'm good with that. I'll pay the $75 and get a commercial entrance. And I think that's all I will do. The east entrance can stay the way it is. Legally, I've already checked into that and that can't be, that's not a problem. And for sale or anything else. And actually legally, I've already checked into this commercial entrance and I don't have to get a commercial entrance permit. But for $75, I'm not gonna sit around here and argue any longer. And there's a question I had for Mark, now I forgot what the hell it was. But yeah. I think, Mark, if you would double check, I believe you're wrong on the fact that I have to get a commercial entrance. Or that even though it's been there 25 years, this is not crossing someone else's property, this is on my own property. To have it's an existing driveway on my own property, it's not like have crossed somebody else's to get to my property. This is on my own. I don't think legally I have to have a permit for that. and I have already checked into this to a certain extent, but,
Through you, Mr. Chair, I guess just on the entrance, so for the west entrance, I think where the township is giving entrance or establishing a new official entrance, my understanding is there has to be an entrance permit granted so that it's formally recognized. So I think that what the $75, what the commercial entrance permit does is just formally recognizes that a west entrance and gives the township and yourself, I guess, that confirmed legal entrance. You don't need any like agreement. I agree the west entrance seems to be entirely free and clear on your property. So no need to deal with any legalities there. I think it's more the east entrance and the question of whether you need, and it sounds like at this point, if you get that west entrance permit formally done, check that box, get the consent finalized and the lot addition done. I suspect at this point it may be more of a discussion between you and the neighboring property owner to the east about whether your entrance can be maintained or if you have that legal right to it. So I think as far as the consent goes, though, that will be a separate item and you can get the consent approved and finalized.
okay, that's all fine with me. I'll take up the commercial entrance fee, get done with the lot addition and zoning. That's not a problem. That'll all be complete. Is that right?
Yeah, so through you, Mr. Chair, I guess just you said that the OLS, the surveyor had put down the pin to show where your west entrance would be, and that's on your property. So if Patricia will just need to see that survey showing that, and then yeah, it should hopefully be clean and easy.
So you've been communicating with, I forgot her name, but Miller's anyhow, Lindsay, and
Yeah,
she
I can,
has all that information.
yep,
That's been
we
done
can,
for two-
speak to your surveyor,
3
to
months.
Julie, I think it was at Miller's.
Miller, yeah.
Yeah. And so, yeah, what we would be looking for with the entrance application is you apply for that entrance, pay that fee, provide that sketch showing that pin as well, and that your entrance is located within your own property.
Okay, can I get an application here?
Yes.
Okay. And quickly, if I could, I'd like to make aware of the east entrance, because that's going to come up at some point. And that everybody's familiar with it. When the township done they allowed the severance to happen. And when they realized there was a problem here, the surveyor stepped over 30 feet. So there wouldn't be a problem. This should have been addressed before there was ever a severance allowed. My brother, or whoever the property owner is next door, should have dealt with that at that time. That severance should have never been allowed without dealing with that first. And instead, they allowed it to step over there 30 feet, which is, there's something wrong with that situation. I opposed that severance to start with for a different reason. Because the first condition on a severance is you got to be able to put a septic system in 900 feet from the lake. You could not do that. If you did, you're in water, in a marsh. The severance went through anyhow. I have no idea. I have been turned down prior to that for not being able to be 900 feet in the water for a septic system. Even though there was 880 feet, it was not enough. This severance got allowed somehow and didn't even address the situation at the driveway. That should have been addressed then. And now they're wanting me to pay for it. So this is gonna come to a head at some time. And so I don't know what the township's prepared to do about that. Because if this goes into a legal battle over this, then it's gonna reflect back onto this severance, which was allowed, that there wasn't, it didn't qualify. And where do we go then? So I think if everybody wants to just get in a row here, Township should contact Doug, which Patricia already has. Make the lot addition. Make me exempt from lot addition fees and zoning fees and all this bull that isn't required for a chunk of property the size of this room. So if they're willing to work with me and try to clean that up that way, then I would cooperate. Other than that, I'm not gonna cooperate. And we will end up in court here probably one day over something very stupid. So anyhow, just something to consider. And as for now, I just pick an application up at the desk here and I'll get that back immediately and we'll go on with life and that part. Okay?
Great.
But please think about this other and let me know one way or another. It's because I'm gonna sell that property soon. And you're right, it'll come up legally and either they'll do a legal document or I have to clean it up. And if I have to clean it up, I have no intention to paying for it. Or paying all these fees and all that stuff. It makes no sense to me. So anyhow, okay.
Thank you,
very
Frank.
much.
Yep. Safe travels. Don't forget, might have left you. Okay. That's the end of our business. I guess, do we need to just, there's nothing to receive there either. It's just a discussion. I don't know how we, do you see the reports? Yeah. Okay. We have a motion to receive the email from Mr. Smith and the reports. Moved by Committee Member Hook, seconded by Committee Member Levier. We'll call the vote. Committee Member Thompson,
Yes.
Committee Member Hook,
Yes.
Committee Member Levier,
Yes.
Committee Member Yanch.
Yes.
That motion is carried. No other business. Motion to adjourn. Moved by Committee Member Yanch, seconded by Committee Member Thompson. Call the vote. Committee Member Thompson,
Yes.
Committee Member Hook.
Yes.
Committee Member Levier,
Yes.
Committee Member Yanch.
Yes.
That motion is carried and this meeting is adjourned. Good morning, everyone.
Thank you.
Mark, for being here.